Good afternoon, everyone. My name is Teilen Celentano, and welcome to today's iteration of the Employment Law Q&A by employmentlawyer.ca. Like I said, my name is Teilen Celentano. I'm an employment lawyer and associate with Samfiru, Tumarkin, LLP, and I work out of our Toronto office. So go ahead and, as always, ask your questions to us directly today. I'll answer them live, whether through Facebook, Twitter, X, YouTube, LinkedIn. You can also go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, or call us at 1-855-821-5900. So I'm going to start today by talking about the recent announced layoffs from Google. So Google announced they either announced or a memo was leaked. It's not quite clear, but the news has hit that they're laying off a few hundred people on their sales team, specifically their ad sales team. And this brings up, this is a great opportunity to talk about a lot of the things that happen when employees are terminated. So when an employee is terminated without cause, generally most employees are terminated without cause, they're entitled to severance. How much severance they can be entitled to varies based on a number of factors. It can be as much as 24, 26 months. And it encompassed within that 24 to 26 month period are minimums under the Employment Standards Act. The Ontario Employment Standards Act outlines the minimum statutory entitlements that employees must be given when they're employed and when they are let go. In Ontario, those minimums are 1 week's termination pay per year of completed service up to a max of 8. The second, if the company has a payroll over $2.5 million and the employee has been there for longer than 5 years, they're entitled to an additional 1 week severance pay per year completed service up to a max of 26. So if you're a 30-year employee working at a company like Google, who unquestionably have a payroll over $2.5 million, your minimum entitlement would be somewhere around 34 weeks. Again, it can be as much as 24, 26 months. It just depends on the facts of the employment. What also frequently comes up when we have clients who are salespeople is that, yes, you are entitled to severance. There's this misconception, this very common misconception that commissioned salespeople are contractors and not entitled to severance and not entitled to their rights. That's just patently false. Even salespeople who earn 100% of their income based on commissions, there's no base, completely variable, they are still entitled to severance pay when they're let go. I don't know where this came from. It's from far before my time. I know my family has told me that on multiple occasions, and I've had the opportunity to frequently tell them they are incorrect. Salespeople are entitled to severance. Salespeople are not contractors. Salespeople are employees who are entitled to severance if they're let go. One of the issues salespeople do frequently run and see is there is generally a strong market for them. So it is easier for them to find new work, which can influence the amount of severance they get. But that notwithstanding, they are entitled to a severance package. We got a question on Facebook from Dean. He says, I recently started a full-time job. Over the last few weeks, my hours have been cut in half. I wouldn't have taken the position if I knew it would be part-time. What are my rights in this situation? Dean, it comes down to largely what's written in the contract, right? And how long you've been working these half hours and what your agreement with the company is. So if you sign a contract that's specified it would be full-time, then them cutting your hours in half is a constructive dismissal. A constructive dismissal can occur in a ton of different ways. There's a ton of different types of constructive dismissals. And one of the common ones we see are a reduction in hours, right? You get paid by the hour and they've cut your hours in half, so they cut your earnings in half. Our courts have recognized that cutting hours in half for an employee, like for any employee, is a substantial change to the terms of their employment. And such that they can pursue a constructive dismissal. Now, if you just started this new job, Dean, you may be in a bit of a tough spot. Shared service employees are entitled to severance, and they are entitled to disproportionately high severance package as compared to an employee who's been there for maybe 4 or 5 years. But in the same breath, it's not huge. So absolutely give us a call, Dean, so we can take a look at your contract. If your contract specified that the hours would vary, if your contract specified that the hours were up to the sole discretion of the company, you may be in a tough spot. But without seeing your contract and really getting to know the nitty-gritty of what's happened in your employment, and also the circumstances which caused you to join the company. If you were induced, if you were recruited into leaving a secure job where you had been for years, only for the company to shortly after you join reduce your hours and constructively dismiss you, there's ample precedent for the fact that you are entitled to an even larger severance package because the company, I don't want to say misrepresented, but almost misrepresented their intentions and pulling you away from a job you had, a job that was secure. A job that was secure, and placing you in a job with precarious hours and precarious earning potential. There's a question on YouTube from HB. If you are accessing personal items on a work device, does this give your employer license to look at your personal emails and other accounts? So recently, this happened. I say recently, it happened within the past couple of years since COVID hit. The Ontario provincial government mandated that all workplaces larger than, I believe it was 10 employees, I may be wrong on the number, but all medium and large sized employers release a policy on how they're monitoring their employees' online use, right? So how they're monitoring their employees' use while they are using the company computers, company laptops, company phones. Generally speaking, HB, no, they don't have carte blanche to go through all of your emails, all of your accounts. If you're banking on a company phone, look at your banking information, all that kind of fun stuff. That being said, they are still likely able to do it, right? So oftentimes, just because somebody can't do something, there's little employees can do to stop it. And it's also would be difficult for employees who are not tech savvy. I myself am comfortable with computers, but would have no way of knowing whether or not a company use their servers to look through your emails and accounts. So as a general rule, I try to advise my employees to keep their personal stuff personal on their own device. That can mean a bunch of different things. That may mean having their own laptop or computer at home where they check their personal email, check their personal bank accounts, do that kind of stuff on their own on a device they can control with software they install themselves. Similarly, even if you have a company phone, it's not a bad idea to have your own. Multiple reasons for that. One, if you were to lose your job for whatever reason, you don't have to worry about changing numbers. I know that's a bigger worry for some than it is others. I personally hate when I change numbers and have to tell everyone in my life, hey, here's my new one. So as a general rule, try to keep your own phone, try to keep your own laptop, and keep that personal stuff personal. Try to keep the work stuff for work. It does get a little precarious when people are let go, and they can look. Just because they might not technically be allowed to look through your stuff doesn't mean they aren't going to do it. Trucker on YouTube asks, I've transferred into another department, which is technically under our sister company, so separate company, very similar name and same HR team overseeing it locally. Is my time with the company reset? So, Trucker, unless you received a severance package when you left the first job, right? So, I'm going to call them Company A and Company B just so my explanation is a little easier. Understanding though that they're different company names, but have names more similar than that. If you work for Company A for 25 years and then transfer to Company B, same building, same HR team, largely same corporate structure, and didn't receive a severance package, then no, your time doesn't reset. In that case, your time would continue. You would still be on to your 26th year of employment for all purposes. That includes vacation pay, that includes termination entitlements, that includes everything. Now, that type of thing is not uncommon. We see it all the time. And there's also a situation where those two companies may be what's called a common and related employer. What we frequently see in our work with Samfiru Tumarkin is people who do work for multiple companies, right? Company A and Company B are technically separate companies, but you, Trucker, as an example, would do the books, would work in accounts receivable for both. And while you might only get paid from Company B, you're frequently doing work for Company A. You're keeping track of the accounts receivable, making sure everything's getting paid on time, and applying the right debits and credits to the right accounts. So in that case, it's likely that both companies would be considered your employer. They would be common and related employers. And they would therefore be joint and severally liable for your severance package. Now, that's a lot of legalese. I understand that. So in English, essentially, it means company A and company B work so closely and you worked for both that they were both your true employer. So they both must pay you a severance package. Now, it doesn't mean you get 24 months from each, nor does it mean you get 12 from one and 12 from the other. What it would mean is between the two of them, they have to pay you 24 months severance. Again, assuming a judge were to award 24 months severance. How much comes from company A and how much comes from company B doesn't matter. What matters is that trucker, in this case, from both company A and company B, gets a total of 24 months severance. So in short, trucker, no, the time with the company doesn't reset. You still have all your previous time accrued. And if you are let go in the future, give us a call and one of our lawyers will help, be able to help you get a severance package from both, likely from both company A and company B, but from at the very least your current company. Next question is from Ash B. So she says, my partner works as a contractor at a factory. He's been there 10 years. They've had a bad few months and aren't renewing contracts, saying they don't owe severance. Is that accurate? Ash, no, it's not. So just because someone is classified as a contractor, it doesn't necessarily mean that's what they are. So a contractor, generally speaking, I'm assuming you mean independent contractor. If you're referring more to a subcontractor, meaning perhaps your husband is an electrician, a mechanic, a plumber, something of that nature, and it's one of his many clients. So he's been working. He's an electrician who goes in to fix things as they arise on a regular basis for the past 10 years. If they are just renewing that not renewing that contract with your husband and his company, Ash, then he might not be entitled to anything. But if it's a situation where he was employed as an independent contractor, but showed up to work every day, showed up to work at the warehouse every day, he worked exclusively for the company, only earned a paycheck from that one company, and just kept on working. And then now the company is just trying to get out of it and not renew the contract. Then no, it is likely that your husband is entitled to a severance package. So what our courts have said is in cases where employees are classified as contractors, they don't just take the courts don't just take that at face value. What our courts will actually do is they will look at the true nature of the relationship and try and establish whether or not the employee was in fact a contractor. Courts look at a number of things. I think the exact verbiage is a non-exhaustive list of factors that are to be considered. But the things that are considered are control, ownership of tools, chance of profit / risk of loss, and organization / integration. So first with control, if your company is the one who sets the rate of pay and it's a non-negotiable rate of pay, they are the ones who say when your husband has to be there and when he can leave. They are the ones who assign him the work and tell him how to do it. They tell him what to wear or at least set a dress code. Those are all indicia. Those are all examples of control that are indicative of somebody being an employee rather than a contractor. With regard to ownership of tools, that's pretty straightforward and pretty intuitive. If the company owns the tools, it is likely you're an employee. You're a contractor who owns his own tools, right? Shows up with your own toolbox to work, then it's more likely that you're a contractor. Third one being chance of profit, risk of loss. Now, a chance of profit is more, earning more pay because you worked longer hours. That's not a chance of profit. Same as someone who might earn a commission. That's not technically a chance of profit. What a chance of profit in the eyes of the court really is a chance to get paid more than what you would be worth as an employee. As an example, people who get paid per job, right? I am going to get paid to fix that as a plumber. I'm going to go get paid to fix that toilet, right? I'm going to charge a flat rate. And if it takes me 8 hours to fix a toilet, I get paid $2,000. Takes me 45 minutes to change the toilet, I make $2,000. And because I am skilled and because I'm a good plumber and I can switch that toilet out in 45 minutes and go to another client and do another one, that's a chance of profit. So if there's a chance of profit or a risk of loss, meaning kind of the inverse of that, I quote a job at $2,000, I end up losing my shirt because I missed a bunch of things, that I end up losing money. That's a risk of loss. If you don't have both of those two things, you're likely an employee. And lastly, integration or organizational test. If your husband's job at the factory is essential, right? With us at a law firm, as a lawyer, the lawyers are essential to our business. Our people in our county department, essential to our business. Our legal assistants, essential to our business. There are our people in our marketing department, essential to our business. Those are all things that are essential to the organization and to the business itself. And it's difficult for companies to establish that essential employees, core to the business's operations, are independent contractors. So all that being said, I don't know where your husband falls on all that kind of stuff, but if he worked for 10 years at one factory, he's likely an employee. And even if he's not, and he was a contractor, there's a good chance he was what's called a dependent contractor. So in addition to employee and independent contractor, our courts have recognized that there's a third category that workers can fall into. And that's a category of dependent contractors. Now, dependent contractors, they're not entitled to vacation pay or public holiday pay like employees are, but they're still entitled to severance, right? So in a situation, they're entitled to severance at the same rate that an employee would otherwise be entitled to. So it's very likely, Ash, that if your husband's worked at this one company for 10 years and he's received all or substantially all of his compensation from this one company, then if they choose them not renewing the contract, he's probably entitled to something, and it's important that he speaks to a lawyer so that they can help him out. He can set up a call with one of our lawyers at employmentlawyer.ca. He can email us at help@employmentlawyer.ca, or you can give us a call at 1-855-821-5900. Also, while I'm on the topic, Ash, there's a chance that your husband may also be entitled to vacation pay and public holiday pay dating back to 10 years. That's always dependent, that's always reviewed on a case-by-case basis by the courts, and depends on when your husband might have learned that he would be entitled to it. But if he's been paid as a contractor, he probably has been paid vacation pay or public holiday pay, and he may be able to pursue the company for that. How much vacation pay, assuming he's a provincially regulated employee, he'd be entitled to 2 weeks service or 2 weeks vacation for the first 5 years of his employment, and then 3 weeks for every year after that. If a company can also choose to give vacation pay instead of vacation time, and that vacation pay is 4% for the first 5 years and 6% for every year after that. And then public holiday pay, it ends up working out to about 3.7% of base pay on a year-over-year basis is what the approximate value is to an employee. Bill Petrez on Facebook. I do Uber and DoorDash on the side. Do I have any rights under the ESA? Bill, there's actually a massive class action that we're working on that's the exact subject of that. So this class action lawsuit has been going on for quite a while, and I know it's on our website, but I don't have the domain for it off the top of my head. But there's a class action going on saying that Uber drivers should be classified as employees, and by the same token, DoorDash drivers should be classified as employees rather than independent contractors as they are currently classified. Now, unfortunately, the law in class action specifically can be slow. That case has already actually gone to the Supreme Court of Canada on a procedural issue prior to, I think it was first heard in 2019 by the Supreme Court. I may be wrong on the date. I think it was the fall of 2019. But they had said that rather than going to court, Uber drivers were supposed to go to binding arbitration in Amsterdam, the Netherlands, at the driver's expense to resolve any and all disputes, rather than pursuing that through the courts in Ontario. Our courts ruled that was an unconscionable contract, meaning patently unfair to the employee, taking advantage of the employees, and threw out that clause. And now they're really getting to the real substance of the matter of whether or not Uber drivers should be employees or contractors. Again, that case is still undecided, but we are working on that case. So if you poke around our website, Bill, you should be able to find out what the latest update is. Candidly, I don't have it at the tip of my fingers. Bernard Stevens asks, my organization is a U.S. company with over 25,000 employees. They are exiting the business in Canada and have assured to give us, they are exiting the business in Canada and have assured to give us a fair severance. What kind of severance they be using the calculator on your website? So Bernard, our calculator at our website is a good place to start. A fair severance package to a Canadian employer and a fair severance package to an American employer are oftentimes two very different things. So like I've mentioned a couple times today, a severance package in Ontario can be as much as 24, 26 months pay, depending on your age, how long you've been with the company, and the availability of similar employment. So a bunch of factors to be considered and to be weighed. And there is no scientific formula or a judge would use to spit out exactly what someone is owed. Our courts have said that it's an art and not a science. And they award what's called a reasonable notice period, meaning one judge might look at a case and say it's worth 24. One judge might say that same case is worth 22, but it's all within that reasonable range of what could be expected. So our severance calculator tries to give you that range, right? But it does not replace speaking to a lawyer. So whenever anybody gets let go, whether they get what they think is a great severance package or what they think is a terrible severance package, my advice is always the same: speak to a lawyer, an employment lawyer, because there are a number of factors that they look at outside of just what's written on paper and outside of what our severance pay calculator can help advise you. So if your company is if your company is closing down shop in Canada, reach out to us, again, employmentlawyer.ca, help@employmentlawyer.ca, and set up a time to speak with one of our lawyers. We'll be able to take a look at everything and really give you an idea of whether or not the deal this U.S. company is offering you is fair and whether or not you should accept it, or whether we're going to, or whether it makes sense to retain one of our lawyers to help fight for more. NDW from YouTube asks, I've been in my position for a little over a year, but have some medical issues and will need to take a medical leave of absence. How do I go about this without losing my job? Can an employer fire me for taking a leave? So they cannot. Both the Ontario Human Rights Code and the Ontario Employment Standards Act protect employees who need to take medical leaves, right? So I'm unsure what your medical leave is, and please don't put in the YouTube comments. Please keep that private. But generally speaking, when people need to go on a medical leave, whatever their condition is, right? Whether it's, you're someone like my father who needs to get his hip replaced, or you had a heart attack, or you had a stroke, or you need to have, you have cancer and you need to go get cancer treatment, whatever it may be, that medical issue is likely going to be a disability. And companies have an obligation under the Human Rights Code to accommodate employee disabilities. One of those accommodations can take the form of providing a medical leave. Further, under the Employment Standards Act, employees are entitled to medical leave. They're entitled to take that medical leave, and when they return, they must be returned to the same job they left, provided it still exists. And if that job has been eliminated, then to a similar one. So if you need to go on a medical leave, first thing to do, get the doctor's note that says it. In that doctor's note, you don't need a full, explanation of what's going on, all that kind of stuff. All the doctor's note needs to say is effective on February 1st or whatever date it is. NDW needs to go on a medical leave of absence and she will completely be unable to work. We expect her to be able to return at this time. If there's no expected date of return, you don't know how long you will be off, then there's no current return to work date. The company, while you are on a medical leave, is allowed to ask you for periodic updates. So they can't we want a new doctor's note every Tuesday at 9 a.m. That's not allowed. But once a quarter, once every 6 months, they're allowed to ask, hey, NDW, what is it looking like? Do you think you'll be able to come back to work anytime soon? Once they give you that option, or once you are able to return to work, making sure that you're at the same rate of pay and in the same position. Sometimes we have clients who try to go back to work, and the company says, look, you were off on a medical leave, you were off maternity leave, and the person we put in your role, we really like that person in that role. So what we want to do instead is put you in this new one. That is also illegal, and you do not have to accept that. You have the right to insist on being returned to your old role. So yes, you have the right to take this medical leave of absence, making sure that you are clearly communicating that to your employer in writing, and that you are giving them the requisite medical documentation is really all you need to do to facilitate it. And then when you go back to work again, giving the company enough heads up time. It's not a situation where you can email them on a Friday, email them today at 1:30 on a Friday and expect to go back up on the following Monday morning. You do need to give them a little bit of heads up, but on your return to work, you don't necessarily need to go back to work full time, 40 hours a week. You are allowed to have accommodations in the workplace. So different chairs, different types of roles, not climbing ladders, not lifting things. You can also have a gradual return to work. So it might look something like 4 hours on Tuesdays, Thursdays for 2 weeks, then 4 hours a day, and then 2 8-hour days and 3 4-hour days. And then you get back to a full 40-hour work week after about 10, 12 weeks. Those are all things that you're allowed. It's things that you should work with your doctor. And if the company gives you a hard time at any point, reach out to us. One of our lawyers will be able to help you out. So Ashby, as a follow-up, just remember her husband was the contractor whose contract wasn't getting renewed. And she's asked if they should have been paying vacation pay the whole time. How many years of vacation pay would it be owed? Would it be the full 10 years? So Ash, it's difficult to say, and it depends on the facts. I know I've said it depends a lot, and it's definitely a stereotype of lawyers is that those are our favorite 2 words, but it does depend on whether or not he knew about an entitlement to vacation pay, or whether or not he knew, right? So our courts say that generally speaking, this just isn't an employment law. This is in every area of law. There's a general 2-year limitation period, meaning people have 2 years from the date on which something happens to start a lawsuit. Now, it's 2 years from the date on when someone discovered something happens. So, for example, if somebody steals something from a safe in your basement, you don't find out for 4 years, and then the day you find out, you start a lawsuit. Well, if you can prove that you started the lawsuit the day you found out, then you can sue, right? So there is precedent for employees who didn't know of an entitlement to vacation pay because they're not lawyers, they never spoken to one and had no reason to speak with one, that they were able to go back, throughout their full employment and get vacation pay and public holiday pay. But there's also cases where that didn't apply. So it's important that your husband reach out to one of our lawyers, and not only talk about the factory closing down and his contract not getting renewed, but also talking about the fact that he never had any vacation pay. And one of our lawyers will, do everything, I'm sure, in their power to get the full 10 years. But what they'd be able to get, like I said, would obviously depend. So that is all my time for today. Thank you, everybody, for joining us. Our next live employment law Q&A is on Monday. My colleague Luke Serta. That's at 1:30 p.m. Mountain Time. So I believe that would be 2:30 p.m. Eastern, but I may be wrong on that. If you have any more questions, feel free to give us a call at 1-855-821-5900 or go to our website at employmentlawyer.ca. Thanks, and I hope everybody has a great day. Bye-bye.